Thank you all. Please be seated. Good morning. This is the time set for oral argument in Stephen Chung versus Jeff Choulet, our case number CACV 18-0460. Each side is allocated 20 minutes for oral argument. You'll need to keep track of your own time at the podium clock. If appellant wishes to reserve a portion of that time for reply, you're happy to do so, but you'll need to keep track of that as well. Out of respect for counsel, I would ask that those who are in attendance make sure their cell phones are off so arguments aren't interrupted and people aren't embarrassed. Our proceedings are being recorded and will be posted to the court's website and then YouTube after that. So please, as you begin your argument, tell us your name and the party that you represent. Please keep in mind we have reviewed the briefs, we've conferenced the case. We encourage you to keep that in mind as you present oral argument. And with that, Mr. Ackerman, you may proceed.
Good morning, Your Honors. My name is Justin Ackerman on behalf of Jeff and Leah Choulet. I'd like to begin, unless the court has any immediate questions, I'd like to begin by just discussing what is and is not at issue in terms of the Rule 60 relief that's been granted in this case. As the court is well aware, the trial court did not serve its final signed 54B judgment as required on any of the parties. And upon notice of that, upon us discovering that, we had informed plaintiff's counsel of that, and they moved for RCAP 9 relief, which this court ruled was untimely. Back to the trial court we go. Plaintiff's counsel files two versions of Rule 60 relief. In their motion to vacate, they sought Rule 60 relief to, in essence, substantively challenge the summary judgment ruling on the breach of contract claim that was subject to the 54B judgment. In their motion for reconsideration, they sought Rule 60 relief for a delayed appeal under Gieler. The trial court heard oral argument and then perplexingly granted both versions of that relief. And that same day, knowing that this would all be coming up to the Court of Appeals, I moved for clarification for the trial court to inform us, did it truly mean to grant both versions of that relief? Did it mean to grant one or the other? And from the reading of its initial ruling, it appeared to me at least that it only intended to grant a delayed appeal because it was discussing the procedural history of the case, which only relates to the failure to serve the final judgment, so on and so forth. So I moved for clarification of that ruling. Unfortunately, Judge Anderson retired a month after I sought clarification of that and did not rule on it just as swiftly as I hoped she would.
Withdrew the
I'm sorry?
She withdrew the minute entries, didn't she?
She withdrew the minute entries, then filed it the same day, the next day. So on the 13th, the initial one was filed. I still to this day don't know why it was withdrawn, but the next day it was refiled, and I renewed my motion for clarification that same day after that was refiled. The court had then set a briefing schedule on this, on the clarification request.
It's odd that you'd need a clarification of a minute entry that's been withdrawn.
Well, it was withdrawn and then refiled the very next day, in almost entirely the same form, with the same issues that I felt were not clear at all whatsoever. And so plaintiff's counsel responded, and then in between when plaintiff's counsel responded and then when my reply was due per the court's scheduling order, the court had signed two orders, one granting plaintiff's motion to vacate and one granting plaintiff's motion for reconsideration, both of which vacated the Rule 54B judgment, which again just provided more confusion on my behalf as to which relief the court was granting in light of the issues in the case and the minute entries. But as a result of the signed orders, I had to file a notice of appeal, otherwise I would be untimely to seek this court's review. The jurisdiction is divested, we come back up here, I asked the court to remand to clarify this record, and the court's remand order is very clear when it remanded for the court to clarify this record. It says that the court can, as a further complication to the appellate record, the trial court actually issued its clarification ruling while this court had jurisdiction. I asked the court not to do that, and it did. And then as a result of that, the remand order said the court may re-enter its clarification order And I raised with the court in my reply in support of the remand that the court also needed to clarify additional issues, such as because of the clarification ruling, which said that the court did not intend to vacate its summary judgment ruling. It only intended to give a delayed appeal, which is what the motion for reconsideration asked for, and not what the motion to vacate asked for. That made clear that its summary judgment ruling was in effect, and so I asked the court to clarify that the attorney's fees ruling that is a result of the summary judgment ruling has also remained in effect. A little caveat to that is the 54B judgment, initial one, the October 2nd one, is the only document in the record granting us the attorney's fees, and once that's vacated, we're now left with a question as to whether that's still in effect. So this all comes back down to the trial court. It clarifies that not only was it only intending to grant a delayed appeal, which is controlled by Gieler, but that the attorney's fees were remaining in effect, and the plaintiffs could pursue a delayed appeal at the end of the case. And so here we are now. And I think the sole issue before this court, because I think everything that the trial court did in clarifying its record is entirely proper in light of not only the remand order from this trial court, but I requested an additional, myself, Rule 60 relief to the extent that the court would be clarifying any orders considered final because it signed those judgments. That's why I requested Rule 60 relief, just to affect the trial court with that authority to clarify the record. And so I think the sole issue before this court is whether the trial court had properly granted a delayed appeal under Rule 60 under Gieler and its progeny. And I think the answer to that question is absolutely not. Gieler and the long line of cases before and after, Park, Davis, the Lennar case, and even the Ninth Circuit cases, it's relying on the Rogers case and there's a Stevens case out there as well that I cited in my briefing. They all make extraordinarily clear that you must show diligence when seeking Rule 60 relief, and when you don't have our Cap 9 relief available to you and you're just asking for it under Rule 60. The diligence...
I'm sorry, and
Sure.
I don't mean to delay some, and I want to get to your argument, but I do have a question going back to I believe it's the final order that was issued by Judge Bailey, and I just want to get your take on it.
Mm-hmm.
She specifically says the court further finds that the ruling on the motion for partial summary judgment number 1 regarding breach of contract issued August 21st, 2017 stands and can be appealed when the case concludes.
Yes.
Well, that's inconsistent with a finding under Rule 54, where it talks about how is that a final judgment on the contract claim if she says you can appeal it after?
Well, that ruling itself is appealable because it's a special ruling made after a final judgment's been entered, and you have to kind of backtrack because the final judgment was entered. Then you have a Rule 60 ruling vacating it, and that ruling in and of itself is appealable, and now you have a ruling clarifying that, so that ruling as well, I believe under Brumet, is also appealable.
But what I think Judge McMurray
Maybe I'm
is
misunderstanding your question. I
referencing.
apologize.
Probably not.
No, go ahead.
No, go ahead. You'll say it cleaner than I did.
It talks about can be appealed when the case concludes.
Yes.
So that, to me, is a 54C judgment, not the 54B judgment. Your answer, I think, quite properly cabinets it to 54B, but that's pretty broad language, and that's what caused me to struggle, at least.
I'm still not understanding your question.
Well, it says
I
when the
apologize.
case concludes,
Yes.
indicating that she doesn't believe the case is concluded.
Well, it isn't, because the initial 54B judgment was just as it indicates, a 54B judgment. There's remaining claims in the case. There's, I believe,
Well, I would agree with you if it said motion for partial summary judgment number 1 regarding the breach of contract issued stands and can be appealed when the matter concludes, meaning I'm ruling on it, but it can be appealed when the matter concludes, i.e. it's not concluded. So it's not 54B.
I'm struggling with your question, Your Honor, because that is the Gieler relief. That is the vacating of the judgment, and this is a unique case in terms of Gieler and the other cases because those cases were finished. There were no remaining claims. There was never a 54B judgment at issue in those claims. It was always a final, I believe, 54C judgment.
54B, yes.
And so as a result of the nature of this case, because it was 54B, I understand why the judge didn't vacate the judgment and then re-enter it, because that's the nature of 54B. There's remaining claims in the case. I believe that the court just felt like, okay, I'm going to vacate this 54B judgment because there's things remaining to be tried in this case. We'll let that go, and then they can appeal this at the end of the case. And that's exactly the Gieler style relief of vacating a judgment so that you can pursue a delayed appeal. I would point to the court as well, 58, the Rule 58, which Gieler harmonizes with Rule 60, that rule explicitly says that the lack of notice of judgment in and of itself is not sufficient to obtain delayed appeal. It's not justification. And Gieler does a good job of explaining you have to show extraordinary circumstances and diligence. And for example, in Gieler, there was a double-stamped final judgment. It had 2 dates at the bottom in terms of one on the top, and there was an affidavit provided in the record explaining how this confusion caused the party who wanted to appeal to misdocket the case, as well as various other issues, like in the Lennar court case, the judgment was sent to the law firm, and then the law firm's docketing system screwed up, didn't put it in the attorney's file. I mean, these are the examples of diligence or the lack thereof that would explain a Rule 60 justification.
Gieler identified 5 things, right? Are those elements or are those factors? I mean, do you have to, in other words, I don't know that I read Gieler as saying you have to show all 5 of those or you could never get relief.
I read them as elements.
Elements.
Elements. You have to show all 5. And it refers to the Watts case, which discusses those as well. It's the lack of notice, it's the lack of prejudice, it's the absence of the prompt filing of a motion, and then the due diligence. And it kind of lists them, I think, pretty clearly in element-based fashion.
Do you read Gieler that way, or do you read the cases collectively that way?
I read Gieler that way because it's the first one to adopt those factors from Watts, and then I read all the cases that follow it to absolutely instill those all 4 requirements.
And we are here, you agree that the decision to grant an untimely appeal, to allow an untimely appeal by a Superior Court is reviewed for an abuse of discretion?
Yes, Your Honor.
What case in Arizona, appellate case, has vacated a trial court's finding that out-of-time appeal should be taken?
I have not found a single one, Your Honor.
I haven't either, so I feel a little better.
That's why I had to look to Ninth Circuit case law, because frankly, in all of the fact situations that I could find in every case discussing this delayed appeal issue, there was due diligence or lack thereof in the record. I think factually it hasn't happened yet for this court to rule on it. I think that's why this case might be opinion worthy, because I think the court should establish when the limits are reached under Gieler and its progeny. And I think this case is the poster child for it. I think just the failure to do nothing and then asking for Rule 60 relief, that is the exact limit that Park initially established, and then every case thereafter has repeated.
What would, and I'm asking you to talk about a hypothetical, but what would due diligence, what would need to be shown for due diligence to be satisfied from your perspective?
I think an affidavit from plaintiff's counsel saying, the final briefing occurred 20 days after final briefing, I checked the docket, nothing was in it. 30 days after, I checked the docket, nothing was in it. I don't think you need to show like 8, 9, 10 times. I think once or twice or 3 times, but some effort demonstrating that you were looking at the docket. This is an electronic docket. It's readily available. It's very clear if you click, there's a hyperlink in my brief, it takes you right to the docket. It shows it was entered. I mean, it's very unambiguous, unlike certain other cases.
Go ahead.
No, I was just going to ask you, it shows that the electronic version the version wasn't sent out. Everybody agrees to that.
Yes.
Was that posted on the court's electronic docket at the time of the entry, or was it posted later? Do we know that in this record?
If you would give me just one moment, Your Honor.
Sure.
I believe the answer is yes, and I would like to point the court to a specific pleading. So if you look at the electronic docket, there is a filing date and then there is a docket date. Filing date is on the left column, docket date is on the right column. The filing date indicates October 2nd, 2017, and that's the date stamp on the judgment. But then the filing date, when I
The
believe
docket
it,
date?
that's the
'Cause
docket date.
The use of the filing date was October 2nd.
I'm sorry, let me just make sure I'm right here. The filing date,
Okay.
October 2nd. The docket date that's indicated on this electronic, available is October 4th, 2017, and I believe that would be when it would be posted on the website where anybody could access it.
And
that's how we found it later in, I believe, early December.
just to clarify, though, you're talking about the face of the judgment itself.
I'm sorry, Your Honor, I'm talking about the civil history, the civil docket sheet that's available. If you click the electronic link, you go online to the Maricopa County Superior Court, enter the case number.
And
This is the public site, not
Yes,
Turbo
public.
Court? Or,
Not
okay.
Turbo Court, it's publicly available.
and where would we find that in the record?
Your Honor, there's a link to it in my briefing. I could give you the exact page once I sit down.
It's in your-
In your briefing below.
In my I believe it's in my briefing below. I can't say with 100%
Okay.
accuracy, but it's definitely in my appellate briefing. And again, that's how we discovered that this was entered.
One way to look at this record is you found it was entered first part of December.
Mhm.
If we presume diligence by you and your colleagues, what message is that to bear on diligence in your opposing counsel not finding it until shortly after you did?
I don't know for sure whether or not our finding would be diligence. We don't have to show that. But
And I understand that,
Sure.
but we're looking at a shadow of something that we want to see, and since we can't see it, we're seeing what else puts light on it.
Your Honor, the cases have been very clear to not try and define what is or is not diligence. They leave that to the discretion of the trial court. But the problem is when there is no showing whatsoever of diligence. That is where the line is, I believe, and that's this record.
And Judge Bailey didn't specifically make the finding of diligence, didn't she just rule on the absolute question?
Judge Bailey did not make any ruling on diligence because my clarification ruling only sought to have her clarify which version of Rule 60 relief it granted so that this court could review the initial ruling.
Did Judge Anderson make any type of finding on diligence?
No, none whatsoever
So
on the
there
record.
was never a finding by the Superior Court of a diligence. They just ruled on the ultimate question.
It did, but in light of the record that was presented to the court, I think this court can clearly reverse that ruling. It doesn't need to remand in any way for that court to make that finding because there's nothing in the record for the court to make that finding. Unless the court has any other questions, I'd like to reserve the remainder of my time.
Very well.
Thank you.
Thank you, counsel. Mr. Fitzgerald.
Good morning, Your Honors. May it please the court. My name is David Fitzgerald. I represent plaintiffs, appellees, cross-appellants, Dr. and Mrs. Chung, and their family limited partnership, the Chungs for short. The court should affirm the order setting aside the judgment. It should affirm the order granting the Chung's motion for reconsideration, and it should vacate the second judge's 11-6-18 order, or at least so much thereof as denies any portion of the Chung's motion to set aside the judgment, and as finds the Choulets are entitled to any attorney's fees pursuant to ARS 12-341-01. The second judge and the trial court should not have considered the Choulets' horizontal appeal.
Well, before we get there, let's go back and talk about the things that we've been discussing with counsel.
Yes, Your Honor.
When you responded to the motion, the Rule 60 motion, what diligence did you allege?
So the first Rule 60, the first raising of Rule 60 was by the trial counsel, and it was, I believe, in December, and they moved under RCAP 9.
Okay, you're not answering my question.
I was trying to,
Well, I just, straightforward, what allegation of diligence did you allege in the, before either Judge Anderson or Judge Bailey? I don't care.
I don't think there's an allegation of actual diligence.
So are you admitting that there is no evidence of diligence in this record?
I don't think the question of diligence can be answered without looking at both prongs of diligence and reasons for the lack, or reasons for the lack thereof. That's the test. And so they both have to be considered. The Supreme Court has said that unless something puts counsel on notice that the judgment has been entered, they would not find a lack of diligence. So I don't agree with the appellant's view of the test.
Well, okay, and you don't have to, but I guess my question is, between the time Judge Anderson took the matter under advisement, so you knew that a judgment was coming, to the time when they alerted you in December that it was posted, and it was posted in October, is there anything in this record to indicate you did anything to search the record, to look for the judgment, to do anything?
Your Honor, I will address that question, but what you are referring to me or to you,
It's the
plaintiff's
regal,
counsel,
it's
not
the
myself.
regal you. It's the regal you.
Oh, thank you, Your
It's
Honor.
your client.
Thank you, Your Honor. My client and counsel of record at the time, I don't know whether they searched the electronic docket, whether they made a telephone call to the clerk or to the judge. So I don't.
So there's nothing in the record to that, to answer that
That is
question?
correct.
Okay.
That is correct.
Can I-
However, I think what is in the record is the reasons that the plaintiff's counsel wouldn't have been searching the record or calling the clerk or the judge or looking at the electronic docket, because there were numerous briefs, including attorney's fees applications, objections on the form of judgment, and other matters that plaintiff's counsel did put before the court. And there was no notice that any of those matters had been taken under advisement. There was no notice that the...
Well, hold on. It's under advisement when the last pleading is filed. She had 60 days to rule. When was the last pleading filed?
I think September 29th, Your Honor.
Okay, so she had 60 days to rule from that day.
Which would make it November 29th or thereabouts.
And so if you made no effort to check the docket from the date she had to take it under advisement till the date she took it under advisement to the date her 60 days expired, you had reason to check.
Under that hypothesis, you didn't really have reason to check until September 29th, and I think those cases November 29th, which is after the deadline to appeal by some 30 days. And I think the cases bear that out, that there is no obligation for counsel to call I use that example because that's in the cases that we cited, calling the clerk's office or calling the judge. Looking at the internet is not much different.
Well, isn't it a lot easier?
I would not say a lot easier.
Well,
Your Honor.
at least, look, this pen is a high-tech device to me, so I'm with you there. But I can, in 30 seconds, go to the court's public website and see if something has happened in the last 60 days. And you have explained why there may be reason to not do something until late November. But even then, the record is silent on anything happening until the opposing counsel said, hey, by the way, here's the judgment.
I agree, Your Honor. But by November 29th or thereabouts, the deadline to appeal was over by some 30 days. So even if they had checked on November 27th, 28th, 29th, November 15th, their deadline was gone.
And that assumes, though, that the publicly available website, which I've just mentioned, showed the entry of the judgment in early October, right? And we don't.
I don't know that for a fact.
Right, and we're the user of the same record that you provide to us. So, I mean, we're in the same spot.
I don't know that for a fact, but to answer a prior question of Your Honor, there is nothing in the briefing below that talks about this electronic docket search. That was first raised on appeal. I think there was discussion during the oral argument about diligence or the lack thereof, all of which was presented to the trial court, and she ruled. Now, she may not have expressly said there was diligence or a reason for the lack thereof, but her ruling itself impliedly determines that there is either diligence or reason for the lack thereof.
But I think that's our questioning is what was argued to either judge? This is the diligence. This is what we did. Because the court can take notice of the lawyer's statement.
Your Honor, the transcript of the oral argument, as well as all of the briefing, is here on appeal. So exactly what was said, counsel did raise the argument that he raises here about diligence or the lack thereof, or the reasons for the lack thereof. But what I was saying is the one argument he didn't make was about this electronic docket search.
And that's my question is, you're limited to what was argued below, and they didn't argue anything below as it relates to we made weekly checks, we did this, we didn't see it, or
That's correct, Your Honor.
or that the docketing didn't happen when it says it happened on the actual judgment.
Or the third alternative is that there are reasons for not checking, and I would draw the analogy for the reasons for not checking the electronic docket, even if it had been raised below, are not substantially different than the reasons one doesn't need to call the clerk's office or the judge's office. They're entitled to rely on service by mail, or now we have also service by electronic process. You can agree to that. So I think federally we get emails that there's been a filing.
Doesn't that, though, sort of prove too much? And let me tell you what I mean by that. And I'm looking, Geyer talked about due diligence, and we've talked about that a fair amount. Let's set that aside for a minute. Or reason for lack thereof, right? And that's what we're kind of focusing on now, given the record that comes to us. The reason for lack thereof has to be something more than we didn't get the judgment. Because in these cases, the judgment is never received.
Correct in part, I think, Your Honor. I think in certain of those cases, counsel actually had the judgment, and yet the higher courts allowed the judgments to be vacated and re-entered.
If it was fuzzy or something like that, you couldn't, illegible, right?
They had them, and I agree that it's got to be something more than merely not getting notice of the entry of judgment. So there are a couple of prongs to that. One, there's not getting notice of the entry of judgment is not necessarily the same thing as not having notice of the judgment itself. If you have the actual judgment but the clerk fails to give the notice, then the failure of the giving of the notice doesn't allow you to take an appeal because you had actual notice, and that ministerial step of providing notice is insufficient.
I understand. That's not this case, but I understand what you're saying. And what I want to do is focus on that aspect of that prong of the one of the Geyer 5.
Yes, Your Honor.
To see how that fits in this case.
The particular prong?
The reason for lack thereof.
Okay. So on the reason for the lack thereof, when the noted, let's see, so there was an underlying summary judgment ruling on the contract claim. The defendants who prevailed on that summary judgment ruling lodged a proposed form of judgment. Roughly at the same time, they filed a motion for attorney's fees under 12-341-01. Plaintiff's counsel objected to the form of judgment and asked for oral argument thereon. Plaintiff's counsel responded in opposition to the motion for attorney's fees and asked for oral argument thereon. At no time was there any indication by the clerk or the originally assigned judge that she had taken the reply briefing, the objections under advisement, and was going to or was not going to allow oral argument. With respect to the motions for attorney's fees, no indication in the record that she had taken those matters under advisement, and whether or not she would allow plaintiff's counsel to present oral argument. So, and then the Davis case, Supreme Court case, says the notice of the lodging or being on notice that a form of judgment had been lodged is not one and the same as being on notice of the entry of judgment.
Right.
So I mean, basically that's our case. There were these things going on roughly at the end of September, beginning of October. And the judge apparently early October signed the judgment, but nothing further happens for 60 days, according to the record. That's what's there. But the plaintiff's counsel, thought they were going to get oral argument, or at least some kind of minute entry indicating whether or not they were going to have oral argument on the motion for fees. They had raised objections to the form of judgment, including whether it was a 54B judgment in the first place, which it isn't.
So let me replay back what I think I'm hearing, and tell me if I've misstated
Yes, Your
that.
Honor.
The reason for lack thereof here is silence and the passage of time.
Silence not only as to the judgment itself and the lack of notice, but as to the other pending pleadings that are sort of subsumed in the judgment, including the motion for attorney's fees in the application. So,
Hold
yes,
on,
Your Honor.
because I want to quote to you what Geiler actually says about
Okay.
this. It says, due diligence or reason for lack thereof by counsel in attempting to be informed of the date of the decision. So it's the attempting to be informed of the date of the decision. So you said we didn't attempt to do it. And then you give an explanation saying, well, we were waiting for the court to rule on the motion for oral argument.
Your Honor, I would respond to that with footnote 7 from the Harotunian, I'm not sure I'm pronouncing it, case 218, Arizona 541. Even though Geiler talks about diligence in counsel attempting to be informed of the judgment, in Geiler, they had the judgment, and there's nothing in the record saying they actually attempted to be informed. Yet
Well, they had it.
Sorry?
Well, they had it, so it wasn't an issue.
They hadn't.
They had the judgment.
Yeah, but the Supreme Court still remanded the case for a determination as to whether or not, in the Supreme Court's view, they would have granted the relief, the 60B relief, even though counsel had not been diligent and I think we're talking about the notice of the entry versus the actual judgment. But counsel, I mean, we have these rules about what is imputed onto counsel. If it's in the counsel's office, he or she is in a tough spot saying, I didn't know about it. My assistant had it. I didn't know about it. But so that in that case, they actually had the judgment and did nothing to basically attempt to find it. So according to the Hartunian case, notwithstanding the language Your Honor just quoted, the Supreme Court would have found the factors sufficient to grant relief. And that gets back to a question of Your Honor about whether these are factors or whether they're elements. And if I read Hartunian, that would suggest they're more like factors than elements. The more timely, the more prejudicial, the more the other exigent circumstances, or the more, sort of like a sliding scale of equities, which is really what Rule 60 relief, at least 60B6, is all about.
And in that, I understand what you're saying, although even Geyer talked about due diligence being of paramount importance, correct? So, I mean, there may be factors, but some are more, important than others, perhaps.
As long as that's with the caveat or reasons for the lack thereof, which I think is the key really, as on this piece of the case for us here on appeal, due diligence, or reason for the lack thereof, and it's in the record below. I've continued to make the point that it's an or standard.
And I understand that you're counsel on appeal, and you are playing the cards that you're dealt, as is always the case when you're brought in. But wouldn't the far better practice have been to think, hey, 30 days have passed. Why don't we look on the website and see what's there?
I believe if that had happened, we wouldn't have what the other counsel refers to as the delayed appeal issue. However, that's not the only issue that the plaintiffs, the Chungs, have briefed. And we also have the other judgment is whether they should have granted relief under 60B for reasons irrespective of the delayed appeal or in combination with the delayed appeal. And in this regard, the defendant's counsel, I think, posits a false dichotomy, that you could have the delayed appeal or you could have the basically vacating for other grounds, but that you couldn't have both. And I think that's not correct. I think that you can have both. The judge could say, I'm going to grant this delayed appeal. Moreover, I'm going to grant 60B relief because now that I relook at it, I think they do have standing or they are real parties in interest. But what if I'm not right on both counts? What if I'm right on one of those two counts? The Court of Appeals can decide whether the granting of both was an abuse of discretion, whether the granting of either was an abuse of discretion, or whether it was abused the discretion to grant neither of them. Here she granted both. The only logical explanation is she both wanted, I'm talking about the originally assigned judge, she both wanted to grant the delayed appeal and she wanted to vacate the judgment for some other reason. And even the second judge...
You totally lost me. If she's vacated the judgment, there's not a 54B issue, is there? She vacated the judgment. There's no judgment.
Right, but on different
So
grounds.
why are we appealing?
A delayed appeal issue is basically vacate the judgment, re-enter, allow them to take the appeal now, even though they were otherwise untimely. Another way to vacate the judgment is she vacated it for, as I said, because she maybe determined that they were the actual party in interest, which she should have determined, and she realized that it was unjust for this result to go forward.
So she's vacating her summary judgment order.
That's what the second judge got to that point itself. She basically said, didn't vacate the underlying summary judgment ruling, vacated the summary judgment, the judgment itself, which would make it there is no 54B judgment anymore because the trial court vacated the 54B judgment.
Well, then you don't need an appeal.
I'm sorry?
You don't need an appeal if there's not a 54B judgment.
The defendants appealed both orders. However, they only briefed one of the issues, which was they only briefed the delayed appeal issue. They didn't brief the argument that she was, and I'm talking about in their opening brief, they didn't brief the argument that the judge abused her discretion somehow by entering the order setting aside the judgment. So, and then they also appealed the second judge's ruling, I think because, I don't know precisely why, but they did appeal it. And the second judge's ruling is not a 54B judgment. However, it's an order entered after the entry of a 54B judgment, which is itself appealable. After opposing counsel appealed the second judge's order, we cross-appealed that order and briefed it in full.
Counsel, I see your time's expired. Thank you
Thank
very
you,
much.
Your Honor. Thank you very much for your consideration.
Mr. Ackerman, rebuttal.
Yes, Your Honor. The type of guesswork that this court is being asked to do is the precise reason why I asked for clarification from the trial court. This court should not encourage a trial court judge, if in fact that's what she did, willy-nilly throwing in two versions of Rule 60 relief with completely different standards for granting such relief. That's precisely why I asked the trial court to clarify its ruling, knowing that this would be in front of the court. And that's precisely why my opening brief only addresses the relief the court actually granted. The trial court explicitly said it denied the relief requested in the motion to vacate that was filed for them, that version of Rule 60 relief. And not only that, that version of Rule 60 relief was improper on its face. It asked the court to revisit rulings it had already made, provided no new arguments other than what was already presented to the trial court. That is not the intent or the use or the proper use of Rule 60. So it was just, even if the trial court did that, I would be arguing it wouldn't be improper before this court. But that's not an issue for this court because the trial court has clarified it didn't grant that relief. With regard to diligence, very quickly, plaintiff's counsel, this court brought up the idea that within 60 days the court needs to rule or should rule on its pending motions. If plaintiff's counsel had checked within 60 days, he would have been beyond the time for filing his appeal. But he would have been within his right to request RCAP 9 relief. And that's precisely the purpose for RCAP 9 is when you don't get relief, you get 30 extra days. It's almost no questions asked. There's a slight requirement that you have to show prejudice. But that relief is intended by the enactment of that rule to assist in this exact situation. If they had checked, they would have been able to ask for that relief. They didn't. I think that is demonstrative of a lack of diligence. The Hertunian case that he cites, that is dealing expressly with RCAP 9 relief. It doesn't deal with Rule 60 relief. I think it's an opposite to any determination by this court. Unless the court has any other questions. Thank you, Your Honor.
Thank you. Counsel, we appreciate your briefing. We appreciate your oral argument today. We'll take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.